Individuals depicted have been arrested but not convicted at the time of story postings. This information does not infer or imply guilt of any actions or activity other than their arrest. We make no warranty or guarantee as to the accuracy of this data.
Hospital arraignment right now.
Gotcha. Okay, thank you, Your Honor.
Run up the black line, black line.
The gentleman in the plaid shirt, what's your name, sir?
Ernest Moore.
Is it Ernest Gaitan Moore, sir?
Yes.
This is Magistrate Echarte. Your criminal case number, sir, is 240-550-5101, sir. You have an attorney? Go ahead, counsel.
Jessica Scheib on
You do
behalf
have
of
an
Mr.
attorney,
Moore.
somebody spoke to you? Counsel
Yes,
Scheib?
yes, yes.
Jessica Scheib on behalf of Mr. Moore, who has formal reading, understands constitutional rights and standards.
I'm gonna enter a plea of not guilty. Court dates are January 11th, 2024, probable cause conference followed by preliminary examination. January 17th, 2024, both matters are in front of Judge King. Mr. Moore, there's some bond conditions in this matter, sir. One is you're not to have any contact with Keisha McCain. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Do you understand that, sir? Mr. Moore, you are not to go to the location of 16835 Collingham Drive, City of Detroit. Do you understand that, sir?
Yes.
You're not to possess any firearms or any other dangerous weapons. You understand that?
Yes.
Counsel Vincent, are you here for the people?
I am, Judge.
Okay. And so let's see. CSC 1, law unlawful imprisonment, count 2, GBH, assault with intended to grave or harmless and murder, or strangulation, felonious assault, an habitual mandatory 25-year sentence. So let's see, 95 felonious assault conviction, 95 felonious assault conviction, 1997 narcotic, and let me see anything else. Narcotics, 2004 felony firearm conviction, felon in possession conviction, 2012. Go ahead, Counsel Vincent.
Yeah, Judge, there's a lot of everything here. We're going to be asking for $2 million. We're going to be asking for it all cash, tether, house arrest, the whole shebang. He's a have for notice, so it's a mandatory 25. In all likelihood, Judge, he's never going to be free again. So we're not going to allow him, at least the people are going to be asking for him not to have the opportunity to be free through the pendency of this case. Your Honor, quite honestly, this incident could be synonymous with a top 5 horror movie of all time. We have an individual allegedly who wasn't happy with how his New Year's Eve night went. And an individual who was living at a residence who came home, not having a dating relationship with this individual. Apparently, he was jealous of the fact that she ended up having a good night. We have a lot of quotes in the investigator's report. This defendant talking about how if she's with somebody else, then he's going to get his. We have another quote talking about how he's not going to jail this time for what he's going to do to her. He's going to go to prison because it's going to be murder. We have an individual who's punching this individual to the point of unconsciousness, strangling this individual to the point of unconsciousness, dragging this individual allegedly back into a house when she ended up trying to escape after she regained consciousness. Let's not forget about the knife that he ended up pulling on this individual in between all of these different assaults that he was doing. And then, Judge, we have this idea that what he wanted was information on her phone. He ultimately gets into her phone and finds out that the information that he thought in his head he was going to find, there wasn't any. She hadn't been doing anything. Your Honor, for whatever reason, assaults continue. And then we have the count 1. the CSC first, where this individual is in and out of consciousness and this defendant is on top of her, having penis to vagina sex with her, unconsensually, after he had beaten her. Judge, it's pretty heinous. We have somebody charged with highly assaultive crimes. We feel as though there's a high likelihood of conviction here. And Judge, one other thing I'd like to point out, because Your Honor is very astute with the investigator's report and everything else. But one thing I want to emphasize here is that additional information that I'm sure defense counsel ended up seeing as well. I believe it's on one of the last pages of the investigator's report. This isn't his first song and dance with this complaint in terms of threats and assaultive behavior. We have a defendant previously who allegedly ended up setting this complainant's house on fire. We have another incident where this defendant allegedly ended up squirting lighter fluid on the complainant and threatened to set her on fire. And this was prior to this incident. The incident where he's facing a life offense, he's a HAB-4 and it's highly assault. Your Honor, with all due respect, we want a high enough cash bond where he doesn't see the light of day through the pendency of this action, because we believe he is never going to see the light of day again.
Thank you. And Counsel Vincent, let me say this. You don't get to set bond or ask for bond for him not to see the light of day. He has rights, and those rights are going to be attributed to him, and Counsel Scheib or Counsel Reagan is going to make sure that his rights are being protected.
And if he has
who's
$2
for the
million,
people?
God bless him, Judge, but that's what we're asking for.
Thank you. Who's for the people? I mean, for the defense.
Your Honor, Jessica Scheib on behalf of Mr. Moore, who we waive formal reading, understands his constitutional rights and stands mute. And Your Honor, thank you for the court for that, because Mr. Moore is presumed innocent unless proven guilty beyond a reasonable doubt. That is his right. And at this time, these are allegations. They are serious allegations, but they're allegations. So he has his rights. He doesn't lose those rights. He has a right to bond if the court finds fit to whatever that bond may be, Your Honor. So at this time, I'm respectfully asking the court to consider a reasonable bond here and consider a GPS tether and house arrest. We understand the court's concern. We understand the safety of the complaining witness based on these allegations. So we will not be contesting to a GPS tether or house arrest, but I do ask the court to give a bond here, a 10% bond, if not the highest personal bond, because he is presumed innocent unless proven guilty beyond a reasonable doubt. He's not on probation or parole, nothing pending. He has a right to trial, and he will have his day in court, Your Honor.
Thank you. All right. I've heard the representations on both sides. The charges are very serious. First count, criminal sexual conduct, first degree. Okay. Under court rule 6.106, pretrial release, the court may, okay, the court finds if the defendant who's charged with criminal sexual conduct in the first degree, the court finds, if the court finds proof of the defendant's guilt is evident or the presumption is great, okay, that unless the court finds by clear and convincing evidence the defendant is not likely to flee or is present danger to any other person, the court doesn't have to give him a bond, can do a remand, okay, in this matter. However, with that being said, the court does believe, based on the clear and convincing standard, is that Mr. Moore is a danger, okay? I'm not going to remand him. I am going to give him a monetary bond in this matter. And one thing that I noted is that the complainant, okay, she regained consciousness. At some point, she realizes that the defendant is on top of her, having sexual intercourse with her. She lost consciousness, and the next thing she knows, she is inside an EMS being transported to the hospital. I will say in the defendant's favor is that he followed EMS to the hospital. And that's what it says in the investigator's report. I'm not sure if Mr. Moore thought that he had gone too far or not. I don't know who called the hospital, but he was following the EMS that was transporting the complainant, Ms. McCain, to the hospital. He followed the EMS to the hospital. But there's a lot of information in the investigator's report that the court finds that Mr. Moore is a danger. Not only that, allegedly dragging her, back inside the house when she's trying to run from the defendant. At some point, the defendant does say he apologizes. He's taken her to the hospital. And then the complainant notices they're not going in the direction of the hospital. Yes, that's where they're going. So there's enough here that the court does believe that Mr. Moore is a danger. Not a remand monetary bond. Cash, no surety, no 10%. $2 million, which I believe will generate a non-affordable bond unless, like Counsel Vincent said, unless he has $2 million. Some people do have it, some people don't. I believe Counsel Shive, this is going to be an unaffordable bond. Is that correct?
This is unaffordable, Your Honor.
Okay. That means, Mr. Moore, you get to go and get another court date this Friday, January 5th, 2024, 9 o'clock in front of Judge McConicle, who is going to look at the bond amount and bond conditions. And let me say that what I've said previously as to the bond conditions, no contact with the complainant, do not go to the Collingham address, no firearms. There's GPS tether, house arrest, and $2 million bond. Cash, not surety, not 10%. January 5th, Judge McConicle is going to look at the bond amount and bond conditions. Anything else, counsels?
No, thank you, Judge. It's always a pleasure.
Thank you.
All right, Tom.
$2 million.
Oh, okay. Wow, okay. 1 second, please. Okay. Argument.
Yeah, Judge, this was a New Year's Eve, you know, I don't know, Mr. Moore, probably, was celebrating a little bit. Now, this is a person, Your Honor, the complaining witness that, he's obviously, known for a while, has had a intimate, well, I don't want to say intimate, but has had a relationship with. He has keys to her house, and even she said it in the report. So this was a situation on New Year's where he, came over to the house, was waiting on her to get back. I'm assuming he might have had a cocktail or two, and she came home eventually. There was a situation where I believe that a phone was involved, going through the cell phones. We talk about, that's probably not the best thing to do or want to do, but sometimes when you're drinking a little bit, and you're getting your feelings, sometimes things happen, Judge, but I do want to point out that, it was a time once the phone situation got resolved, I guess, to a point, there might have been, excess, contact between the two parties. Now, it says that the complaining witness came out of the house and got into the car with Mr. Moore. So it tells me that they, she wasn't trying to get away. She got in the car. He was going to take her to the hospital, allegedly, she says. But then the car went another direction and it came back to the house. And as the report reads, she, passed out a little bit. I don't know if she had a couple cocktails. I don't know. I just know that Judge, she awakened. She was going in an EMS, but Mr. Moore was the one I believe, Judge, that contacted the EMS. She was kind of out of it. He even followed the EMS to the hospital. So it wasn't like he, trying to.
He kind of like was the arsonist who threw the gasoline all around and lit the place on fire and then called the fire department to.
Well, I don't know. I don't want to put it like that because I don't know.
That's what it kind of sounds like, though. From the allegations, he beat her allegedly because she wouldn't let him see her phone. He finally gets in the phone and finds out that there's nothing in the phone. And he allegedly feels guilty. And so he's going to take her to the hospital after his beating. But then somehow they U-turn it out and then they get back. She passes out allegedly from the beating or whatever causes her to lose consciousness. And she's waking up. She wakes up to intercourse. That's the allegation.
That's the
allegation.
Yeah, that's the allegation.
That's the allegation.
Allegation.
But we can't give him a lot of credit for he was going to follow the ambulance after he beat her, though, allegedly.
That's part of the allegation, though, Joe. We got to give him. I think that's important because if you do one part without the other. If you want to go with the beatings and all that,
no, I'm saying he did it. But I'm saying we're not gonna make him like a gentleman for following the EMS after the alleged beating because she was asleep at home. So it really shouldn't have been a lot of EMS.
He called the EMS, I'm assuming he called because she said she's awakened in the EMS. So somebody called the EMS. Right. So maybe, she felt uneasy. I don't know, Judge. I don't know if they made up. They had, I don't know what happened. I wasn't there. I just know that the prosecutor, in order to make a case, has to write it up a certain way. And this is how they wrote it up. They trying to get probable cause. But I'm saying, Judge, there's certain factors that are a little confusing. You know what I'm saying? So I'm saying that it's probably like the court says, jealousy gone wrong. And now, I think separation is a good thing. Right now, he has key to the house. This is not a random situation, Judge. I don't want you to think Mr. Moore goes out here randomly. This was an isolated situation. I think drinking got out of hand and jealousy maybe a little bit. But I think if you separate the two, put a tether on them, no contact, I think that would suffice. That would keep her in a situation, no alcohol, and put an alcohol tether on. No alcohol while this matter's pending. He has a good job, Judge. He has 4 children. He takes care of. He works, makes car parts. So he has a very good job, Judge. This is an unfortunate situation, Judge. And I think that it's isolated. I do think it's isolated. So I'm going to ask the court to reduce the bond, Judge, with no contact whatsoever, GPS tether and alcohol tether.
Okay. Mr. Prosecutor, make it quick, please. Thank you.
Sure, Judge. There are a lot of I thinks and I assumes, and this is random and this is isolated. If I could, Judge, just point your attention to the second to last page of the report. Mr. Reagan may want to do that as well in terms of whether or not this is an isolated incident. Previously, he set her house on fire. Previously, he ended up pouring gasoline on her and told her he was going to light her on fire. Previously, he ended up having a girlfriend of his point a firearm at this woman. The same woman who this defendant said, this time, I'm not going to jail. I'm going to go to prison because I'm going to murder you. So, I don't have any.
Court haven't heard. All right, court haven't heard. I'm sorry, Mr. Reagan.
No, I just don't have I don't know about any of the those particular items that Mr. Vincent is speaking of, Judge. But
court haven't heard the arguments for counsel. Bond is currently set at $2 million cash. The $2 million bond is an unaffordable bond. Court finds that in order to have an unaffordable bond, there must be a showing of a danger to the community, danger to the complainant, or flight risk. The court will, I guess, adopt Mr. Reagan's argument that Mr. Moore is not a random person committing home invasions and CSCs, but that we do have a situation where, this is not quite the way to bring in the new year. you know, upset because allegedly upset that, you know, someone that you know or have a child in common is, I guess, not home, and making assumptions of what she was doing, you know, and wanting to get into her personal property. And because she won't allow you to invade her privacy, it leads to situations that, you know, they are what they are, and that will be litigated at a next step. And so right now we're only dealing with bond. So court does find a $2 million bond to be excessive. Court is going to reduce the bond from $2 million to 500,000 cash. No contact with the complaining witness, GPS tether, house arrest, and an alcohol tether. Thank you. And just a bit of advice, you know, Mr. Moore, you should, you know, hold your phone sacred, and you don't have to let anybody get into your phone, because that's your phone. And other people's phone, unless they're your children, you know, you don't have a right to, you know, ask or, you know, to get into someone else's phone, because that's their phone, it's their property. And we have to kind of respect each other's properties as adults. Now, children don't have the same rights to privacy with parents, but adults do have the right to, you know, their phone. So just a little tip in the future. Have a good day, sir. What was the case? Mr. Wood.